This is State of Idaho versus Tommy Morgan, CR 2022-2790. And we're joined by Counsel Neal and Anderson for the sentencing. Good morning, sir. Go ahead and have a seat there. Counsel will sit by your side. We're conducting sentencing this morning, and I believe we're proceeding. Is that accurate?
Yes.
Unless I'm informed here right now, we're proceeding.
Okay.
No, sir.
All right. I think. Okay. I've got a few questions for you that will help us determine whether we're ready for sentencing, and that is, did you have a chance to review the pre-sentence materials?
Yesterday afternoon.
All right. And as you went through that, was there anything among them that needed any sort of clarification or correction?
Well, I would like to, I don't know how to do this. I'd like to clarify that the charges against me state that starting in 2016, I continuously stuck my hand down in the pants and played with them. I did it once, Your Honor, and that was in 2020. What I was doing during that time was I would put my hand on under her waistband and smooth the skin out. With that, I started doing that after I witnessed her grandmother doing that, and it reminded me of when I grew up, my mother would have me or my sister put our hands up underneath her bra strap and smooth the skin out, and the elastic is wrinkled.
So that type of comment, and I welcome it. It's what I read in the materials as well. Your response to that is likely more appropriate to be made at the conclusion of the arguments of the attorneys. And I will be giving you the final opportunity to address the court before I pronounce sentence. And I could have you make those kinds of statements then. And so that essentially is a dispute between the version that is provided by police reports and the compilers of the pre-sentence investigator. What I would be asking for at this stage of the sentencing, is there any other than the description of the events itself that needs clarification, such as, you know, employment history, dates of birth, those factual things that make up the pre-sentence report that we would want to correct now, as opposed to having those remain in the record there.
I did not notice any of that.
Okay. Then may I rely upon the contents of that report for sentencing? Again, recognizing you'll be able to acknowledge or dispute certain conduct that has been alleged, and I'll have comments about that in response to what you say, but are you okay if I rely upon the contents of the report?
Yes, Your Honor.
Okay, very good. Are there going to be any witnesses today by the defense?
No, Judge.
Are there going to be any witnesses or an impact statement from the state?
There's an impact statement, and if I may have just a moment, we may call a witness.
Okay.
Quick, just a moment. Your Honor, if it would please the court, I mean, I think we could start with Detective Graham.
Okay, as a witness, then we'll invite him forward. Sir, if you'll come and stand before the bench here, we'll get you placed under oath. Go ahead and raise your right hand.
Do you solemnly swear that the testimony you are about to give in this pending cause shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And he's going to be sitting in the witness stand?
That is
Okay,
correct.
yeah.
All right, you may inquire.
Thank you. Good, please, the court and counsel. So could you state your name and spell your last name for the record?
Justin Graham, Gramm,
And where are you employed?
City of Idaho Falls.
What do you do for them?
I'm a detective in the Special Operations Bureau.
All right. Are you familiar with Tom Morgan?
I am.
And how are you familiar with him?
I investigate this case that we're presently here for.
And can you see him in the courtroom?
I do.
And can you point to him and describe something he's wearing?
He's at the defendant's table in a brown colored overshirt with a gray undershirt, long sleeve with glasses.
And I'm going to draw your attention. During your investigation, did you interview Mr. Morgan?
I did.
And how many times?
I believe just one formal in-person interview.
All right. And during that interview, did you speak with him about some physical contact between him and a young child?
Yes, I did.
All right. We won't mention the child's name just for privacy. But what was the relationship between Mr. Morgan and the child?
His grandfather-granddaughter relationship.
All right. And what kind of statements did Mr. Morgan relay to you about that physical contact that you had?
That it occurred over a long period of time. Based on the years that were given and the frequency in which the victim visited the home, we tried to ballpark a rough estimate as to how many times these interactions occurred. And I believe 100 seemed to be plausible based on the investigation. The contact was manual to genital in nature, non-accidental. He also, when asked, I had him draw an outline of his hand and he indicated how far he digitally penetrated the victim.
And how old was the victim when this contact started?
I'd have to look at my report, I don't recall.
Can you give an approximate age?
It'd really be a guess at this point.
All right. And were the statements consistent about how many times and the nature? Or
Based on the disclosure from the victim,
were they consistent during his interview with you? Did he say the same thing over and over, or did he change his story?
it slowly evolved. It was more minimized at the start. Towards the end of the interview, it seemed to be more clear and honest as he thanked me at the end because he felt he needed to discuss these matters.
All right. That's all the questions I have for Detective Graham.
Any cross-examination?
None, Judge.
Okay, sir, thank you. The court has no questions. You can step down.
The victim's mother.
Place you at the table.
Okay.
And she's just using her phone. That's where
Right.
she has her statement.
Statements on my phone.
Okay.
Do I just begin whenever? Okay.
Just begin by stating your name.
Okay. I am the mother of the 11-year-old victim who was sexually abused by her Papa Tom for over 5 years. I felt the need to express the depths of suffering Tom Morgan has inflicted upon our family. is an angel on earth and has the kindest heart I have ever known. She is truly a blessing from above, and we all fell in love with her the moment we found out she existed. She is a light in all of our lives. The trauma has changed my sweet, innocent little girl. She has been riddled with fear, anxiety, vulnerability, depression, and sleepless nights. This ordeal has taken a tremendous toll on our family as we work to comfort one another through this difficult time. We have had to make drastic changes in our routines, including frequent therapy sessions, medications, and extra security in order for my child to feel safe. All of these things have come at a significant emotional and financial cost to us all. As a mother, there are no words to describe the helplessness, hopelessness, and heartache I have felt for my child experiencing this type of devastating trauma. The emotional turmoil she has undergone cannot be quantified. Every day I see her battle with this and the effects it has had on her behavior, emotions, and overall well-being. The amount of damage Tom has caused to our family is unspeakable. The facts that have come to light have been so horrific. It has reached us all in ways we never could imagine. It has ripped open old wounds we work tirelessly to heal. Our family is grasping at straws to comfort and try to heal, as well as shield ourselves from this horrendous nightmare. We were groomed by a man we all adored. He came into our lives over 20 years ago and made promises to be our sanctuary. We thought he was a safe place, but instead he molested one of the most innocent and vulnerable members of our family. He willingly abused a baby we all trusted him to protect. He was the mastermind of keeping the secret. How could the perfect guy ever do such a thing? Whenever you needed anything, Tom was always there to help. It didn't matter the time of day, he was a phone call away. Tom burdened with his sick and twisted mind for many years, while conditioning her to believe that it was just tickling, that it was normal. We looked up to him as a good man, a father. He was a grandpa to 2 little girls. One of them he began preying on after her 5th birthday. It wasn't until she began to get a little bit older and started to understand that the abuse she was enduring was in fact not normal. In February of 2021, she came to me and said, "Sometimes when Papa tickles me, he hurts me and touches me where I don't want him to." The next day, his grandmother and I went to the police department and reported him. I fear that if Tom Morgan is released, that he will prey on another young victim. He takes not even a shred of accountability for his actions, and he blames the victim. He is sick. I implore the court to consider the immense damage this crime has had on my child and my family. I ask the perpetrator be held accountable to the full extent of law for his actions, and that justice be served for my sweet, innocent little girl. And know one thing, the wake of your sinking ship will be felt for generations. I hope this wreckage is never found. This is your legacy.
All right, thank you.
Your Honor, I know that the court typically likes to know who's here, and I'm wondering if, would you be able to tell the court who's here?
Yes, I have my mother, my aunt, my father, my best friends.
Thank you. All right, counsel, if you'll share the state's sentencing recommendation.
I read a story about the prosecutor down in Bingham County talking about the effect that the case had on him, and trying to equate that to what the family's going through, which is difficult to understand. And I find myself in that same position today because I just find everything I've read in this PSI just so disturbing. For this individual, and in the PSC as well, to try to minimize, cast blame, and in some ways suggest that this young 5 or 6 year old child was to blame for his actions. It's difficult for me to comprehend. And it's difficult for me to understand that that the PSC, the psychosexual evaluation, talked about his risk is low, because the risk has to be associated with his ability to understand the severity of what he did, his culpability. And I don't think he has any grasp on the effect and the consequence. You know, I don't understand why there wouldn't be, you know, the kind of full acceptance for what he did that he apparently gave to Detective Graham before this court today, and certainly before the family, who really need to hear that. The opposite of what they need to hear is a suggestion that somehow he has less responsibility, he had less culpability, or that in some way this was less severe than it really was. I can't even begin to understand the devastating effect that this has had on this family, but it certainly cannot be in any way mitigated by just the dishonest, inconsistent, and unreasonable claims that this defendant has made about this case. And that's all before we start talking about the effect on a 5-year-old child who has experienced 100 molestations by this man. That will never go away. That consequence will never be fully healed. And that's something that she did nothing, absolutely nothing to deserve. So I just find the excuses and the rationalizations and the minimalizations to show that this defendant has no idea, just no idea what he's done. And I'm not willing that he have the opportunity to do that again to anybody else. He's 73 years old. I think in a case, given these circumstances, that a 6-year fixed sentence is appropriate, but more importantly, that he always be under the supervision of the parole commission. So I'm asking that the court sentence this defendant to life with the fixed sentence being 6 years. That will give him supervision for the remainder of his life. In some cases, you know, that might seem extreme, but in this particular case, at 73 years old, I think that it is appropriate that if we set a 25-year indeterminate, we would have the same effect. And there's just no reason to believe that Mr. Morgan ever needs to be unsupervised in our community. So that's the recommendation of the state.
Thank you. Any comments towards restitution?
Your Honor, I know that there's been a request for, I think, $1,200 that goes to the Victims Relief Fund that's previously been ordered or awarded by them. Also, we would ask that the no contact order remain in effect throughout the entirety of the sentence.
Mr. Anderson.
Thank you, Judge. I share State's Counsel's sentiments about these cases are extremely difficult. They're difficult to talk in public with people that aren't only related to the victims, but are, whether they're media or people that are court personnel, because these cases force us to talk about them in a somewhat analytical manner. And it makes it look like when you do that, that you're weighing one option against another. And I can assure that all the people present here were not. We are forced to do that because of the system. And I give a similar talk like this to juries before, sometimes when I've had to try cases like this, when we have witnesses actually on the stand, whether it be a psychiatrist like Dr. Hatzenbuehler or other people. It is difficult, but I can assure everyone present or other people that might read about this in a paper, it is necessary, and we're forced to do that. And it's even necessary for judges to do it, for witnesses, law enforcement to do it. So I am going to engage in some of that comparison. I have been trained in this area, as even back in the day when I was on the state side. And I went probably 30 years ago, 35, maybe 35 years ago to my first 2-day complete seminar on these types of cases about how to investigate these, how to interview witnesses, how to do things. And they engage, albeit away from the public eye, in those same types of quantitative and qualitative analyses that I'm about to go into here. I do share State's Counsel's recognition that we do have experts here that have also analyzed this case in a similar light that I'm talking about. We have both a pre-sentence investigator here, and we have an eminently qualified psychiatrist that did do the psychosexual in this case. It's a component of the PSI. And although I agree with State's Counsel, this is going to affect forever and significantly members of the family forever. However, other than sheer punishment, we have to look at other things that the court has to do, and I know the court will cover this, so I'm not going to lecture the court on its responsibilities or how it goes about this, but I would like to point out that it is extremely significant that this man that's 73 years old has absolutely no criminal background, has absolutely no other charges like this. And I think that's a significant matter, and it was found to be significant by both the pre-sentence investigator and by Dr. Hatzenbuehler. The other thing is his age and likelihood for recidivism, whether it is with this family or potential there are people in this community, and that was found to be very low by Dr. Hatzenbuehler. She found him, and I know there's some dispute over what is the level of his recognition of his behavior. She found him to be a very low-risk individual, and that he would be highly amenable, she didn't use the word highly, but highly amenable to education through, she does use even in the community counseling, sex offender counseling. And so we're asking the judge, Your Honor, to consider something not as severe as State's Counsel's recommending. He has no objection to, at his age, always being under supervision. That's not a problem. But what is a problem is the determination of what's going to be the fixed portion of of a unified sentence. State's counsel suggests 6 years. We would suggest something short of that going forward here today, probably in the realm of 2 years or 4 years. He indicates to me that he's already been incarcerated. He would be entitled, obviously, to the 16 months he's been incarcerated. So he's done, if you want to call that without counseling, 16 months of punitive time that a lot of people always forget when these matters come up before a court. And I would assert to the court that the court consider something other than just giving him dead time and not giving him the beginning of counseling. If he were to ever be paroled, that the court would consider retaining jurisdiction in this matter. I can assert to the court I'm not a modern day expert on IDOC regs, but I am aware that when we've had other representatives from IDOC testify, they don't really have in the main system over there anything as far as good counseling, and they have admitted in testimony that even when they have people with mental illnesses or things like that, about the only thing they're equipped to do in the main system is give them prescribed medication. If he were to be allowed to be on a retained jurisdiction, he would get that. It would be in furtherance of punishment. They know when they're in that system over there what happens if they don't comply. But they also get a lot more programming. It's not the main sex offender counseling that would be as in-depth or as long or as continuous if he was on continual supervision, but it would assist him in getting into that program. The court touched on restitution slightly. He has no objection to that. I would state that, and while I had no contact and I did not appear in a case wherein he was served with divorce, I did have contact with his wife's attorney with regard to two issues. One was a quadro, and one was the fact that he made an accommodation, at least he expressed it, and it was expressed to the attorney, that he gave up his interest in a pretty substantial asset that does produce income. And it was in anticipation, and it was in furtherance of recognizing that would require funds. And it is a great, the totality of the amount is a great deal more than the statutory amount for these types of cases, and it will be ongoing, and that is to be supervised however his mother feels fit to do that. And I don't know, he did tell me that there was some communication, I don't know if it was through her attorney or whatever, and him, whether it be phone calls, but that was made clear to the attorney. Not having been part of that, I don't know what was communicated to them. But suffice it to say, that is closed now, and that asset is in their column. And again, here we are qualifying, quantifying things, making it sound like, well, there's some money going in a certain direction, so therefore this shouldn't be. But all I'm doing is informing the court that that's one of the considerations of going to court, even if Your Honor's going to decide whether to make a max award or a half award or something like that. But nevertheless, we're forced to quantify things just like we would if it was an insurance claim and there had been a death on a highway. Contrary to what some people may know, and Dr. Hassenbuehler does touch upon this, and I realize the pre-sentence investigator touches on it in a little bit of a different way. He has expressed great remorse about this and continues to. And I think if he was given the right counseling, he would come to grips with expressing even more. Depending on what Your Honor intends to do, I'll be frank with you. Again, back when I worked for the state, there was a real difficulty over in Ada County on what to do with offenses of this type and perpetrators. And it was by a group who used the acronym SANE, similar to the acronym we understand it to be, sexual abuse nurse examiners, but they called that SANE, and I don't know if it was a group of them, but what they got together, they back then approached the legislature about the fact that they were giving maximum sentences to perpetrators, and they were even topping their time, younger men. They would top their time and still come out with absolutely zero reprogramming, absolutely zero stuff. Other than a life sentence, they'd go in there and do 15 years and reoffend within 6 months. And they were trying to get the judiciary, the health and welfare at that time played a bigger role, and counselors to understand that rather than do that, the resources would be greater value if they were put into starting at the get-go, making sure that recidivism is just minimized. I don't think they got their full goal, but in this case, I think it would go a long way if the court listened very carefully, as difficult as it may be, to both the recommendation of Dr. Hatzenbuehler and including the recommendation in the PSI, although the PSI investigator makes some very valid points. I can't deny that to State's Counsel, makes some very valid points, but that investigator also quotes Dr. Hatzenbuehler and comes up and acknowledges the low score and the likelihood of recidivation. And we ask the court to consider those carefully vis-a-vis the public's initial reaction, and even sometimes whether it's Mr. Morgan, I'm not saying this happened with Mr. Morgan, or people in my family knowing the business that I do and the people that I have all over the state, they wince at what to do. The first knee-jerk reaction is to, just go to the guillotine. So I'm asking the court to consider all those complicated things, and that's another reason I'm glad that men like you, Judge, are good qualified judges. And I mean that both in a backhanded way and a straightforward way, that you have the difficult thing of fashioning a sentence here. That's not an easy thing to do. And when you consider all of those things, all of those distasteful things, that's a very difficult thing to do. So we're asking that the court consider a lesser fixed. I won't quibble with the state about the tail end of a unified sentence or things like that, but I would really encourage Your Honor to consider something that puts him immediately on the threshold of getting education that he needs, such as something like a retained jurisdiction in this matter. That's all I have to say, Judge.
Okay, thank you. Mr. Neal, do you have any rebuttal comment?
Just briefly, Your Honor. I don't, I don't dispute that we have a criminal history here that doesn't have any prior convictions or crimes, but I think it's misplaced in a case like this to simply emphasize the factor of recidivism. If this was a burglary and he had no prior record, obviously, that's something to take into consideration. If it's a homicide case, recidivism does not become a significant factor. The fact that we could give treatment to somebody so that he wouldn't commit murder in the future, that just becomes absurd. The reason that these particular cases are just so severe is that this child's life has been permanently disturbed and permanently altered. That can't be undone. And that's not Dr. Hatzenberger's realm. She's not in the realm of establishing whether or not this is a severe crime. I think that the court is already aware. So as far as retribution, as far as deterrence. Each of those things have to factor in regardless of the prior lack of criminal history, just the absolute severity of what we're talking with. I'm also, cognizant of the fact that society will be protected by having some kind of sex offender treatment. And the fact is the Department of Correction is set up for those kind of eventualities. Whether that be while he is serving time or if he was to be paroled, that would be a program that they can control. So really, the question comes down to are these other suggested options, are they justified by the psychosexual evaluation? I don't think they are, because I find that the statements between the officer and in his own version and in the psychosexual evaluation just are very inconsistent. And yet there's a polygraph that had no significant reaction. Well, inconsistent statements can't all be true. And yet I think in this particular situation, the evidence is that inconsistent statements were given to the doctor in the psychosexual evaluation, and a polygraph, which is obviously not perfect, didn't detect any kind of deception. So I'm not sure, based on that the results are completely trustworthy. It's not to cast anything on the doctor, but she only has the information that's coming into her through the psychosexual evaluation program. There's something that we just need to be clarifying. There was mention, I think, in the PSI and now in sentencing, that a piece of property, a commercial property, was provided. This is actually a piece of property that's a bit dilapidated. With the folks there they're almost 2 years behind in payments. This is not a money maker. And so the potential perhaps is there if somebody were to invest a lot of money into it, but the idea that this is somehow compensation that's going to make this young girl whole, I think that's just unrealistic. And I only raise that because it's been raised to the court. Your Honor, this is clearly a prison case, and I think that it's consistent with other cases of similar nature that we've had recently. Consistency leads to fairness and potentially justice. And so I think in Mr. Watkins' case, it would be potentially unjust to provide a lesser punishment, because we have a victim here who has she doesn't have the capability at this age to stand before this court in any reasonable fashion to describe the effect, let alone to understand it. So for that reason, we'd ask the court to follow the state's recommendations.
All right, thank you. Mr. Morgan, we talked earlier about your opportunity to address the court, and that time has arrived. Would you like to make a statement?
Yes, Your Honor. I was reading some of the verbiage here, and, well, when I put down the PSI, I was trying to describe what items that happened or actions. I do not try to blame her for anything. That's a misconception. I don't know. I guess I communicate that, but I didn't mean to. I accept full responsibility for what I did. I just try to describe different things that happened while we were there acting. Also, she made a statement that I tickled her and hurt her. If I hurt her while I was tickling her, that was strictly an accident. I did not mean to. I tried to do it gently because I've been tickled very close. And so, nowhere did I ever try to hurt her. If I did, it was strictly an accident. I do accept, like I say, full responsibility for what I've done. Don't try to blame her for anything. Well, I'm just gonna apologize. And I was gonna say that she is not at fault for anything. And she should not be embarrassed or ashamed of anything that happened, because it's all my fault. The restitution I signed over, and my attorney had mentioned it, I signed over a piece of property worth between $300,000 and $400,000 that has a potential income of $1,000 a month. I signed this over a year ago, one, to show my sincerity of my apology, and to show that I take full responsibility for what I have done. I mentioned earlier about the idea, the deal where I put my hand under the waistband of her leggings. And like I said, I do that just to, I witnessed her grandmother doing it, and that reminded me of when I was growing up, my mother would ask us to do the same thing on her back. I have I know I will never do it again. I know, the question is, do you guys believe it?
Just address the judge.
Okay, I'm sorry. I know I will never do it again. I was convinced of that when this happened. I was reporting. And I do realize the seriousness of it. I might not communicate that in my writings and stuff, but I know I'll never redo it again, and I am deeply sorry. I can't express that enough. And like I say, other than restitution, trying to show how sincere I am, my apology, I don't know what else to do. I would gladly volunteer for a writer to take a psychologist treatment or counseling or whatever you recommend, if I deem that is necessary, and it sounds like I do. And so therefore I'm quite open to that. I also kept mentioning though that I kept trying to blame the victim. I do not. I mean, I guess the way I worded it was wrong, but it's not her fault. It's strictly my fault. And I guess that's it. I don't know what else to say. I'm just, I'm lost. So, thank you, Laura, for the opportunity.
Well, thank you, Mr. Morgan, for your comments. Are you fully satisfied with the representation of your counsel?
Yeah, I've had questions about it, but yes, Your Honor, I am. I mean, there's always going to be questions.
Sure, and the nature of an attorney-client relationship is such that there might be those heated discussions. I present that question to you and accept what you have said. I would note that he's been effective in his arguments today, and I'll comment upon those. Now is my opportunity to address what I've heard. And counsel, do you have any legal reason why the court should not proceed?
No, Judge.
All right, well, thank you. To all who have shared and participated in today's sentencing, there are a number of things that have struck me. I have listened carefully and taken notes and hope to share a few of my responses to the things I've heard today, and in so doing pronounce the sentence. The first thing that I would comment upon is the introduction to the nature of this type of case by both attorneys, recognizing the challenging aspect to these types of cases. And it is clear that these cases are difficult. They're difficult for the court, as noted by counsel. They're difficult for the attorneys involved. Certainly, they do not compare to the trauma, to the pain and suffering of the victim. But it is fair to say that when the court is obligated to apply these 4 objectives of criminal punishment, that there are reasons why it becomes difficult and challenging. And there are a number of factors. In every case, there are circumstances that present that are distinct from one to another. And it is true that there is a great wincing when one is exposed to the nature of these types of cases. The court, as counsel has done, and as how the evaluator has done, looks at the conduct involved, looks at the frequency of the wrongdoing, looks at the age of the victim, the age of the offender. And it is fair to say that there are analyses of quantifying and qualifying some of these, ultimately coming to the conclusion of should one plead guilty, should one go to trial, should the court impose a prison sentence versus community supervision. And in this case, it is clear that this is in fact a prison case. The comment from the mother of this case, which struck me, is that lives have been changed as a result of your conduct. And I sense that. And frankly know it to be true. And that has been because of your actions. It's also fair to say that words cannot describe the ways in which lives have been changed because of your actions. The court, in reviewing the materials in your response to the inquiry to describe your version of the events, also was striking to me. And even listening today to descriptions of a hand, down pants and loosening a waistband, and that was done to others, is ridiculous to me. And I make no sense of it. There is a great disparity between your description of what occurred and what the court reviews in the pre-sentence investigation. Now, there are 4 objectives that I must employ when fashioning a sentence, and they include protection of society, deterrence to you and to others, rehabilitation, and punishment for the wrongdoing. Each of these are important in this matter. The protection of society goes to the nature of the offense, the harm that has been caused. The deterrence turns on your counsel's argument that there has been no prior or significant issues in your history. And he characterizes that as significant, and I do as well. These are things that must be acknowledged by this court, including your age. The risk level is associated by the evaluator, that I think all counsel place a great deal of trust and judgment in those evaluations and conclusions. You've been incarcerated a significant amount of time, and you pled guilty, making yourself accountable to the court and submitting short of trial, which is a benefit to all those involved. That hurt and harm that you caused would have been compounded, I believe, by requiring this young child to testify. You state today that you did not intend to hurt her, but you did. You hurt her a great deal. I do find redeeming in your statement that you don't place blame upon her. I'm pleased that you said that, because none of it should be attributed to her in any way, nor anyone else but you. So it's true that the initial reaction to all of this is one of wincing, and that wincing remains. It remains after I consider all of these mitigating and redeeming attributes to your set of circumstances, and because of that, recognizing the need for rehabilitation and punishment for the wrongdoing, my view is that a fixed term of 5 years with an indeterminate term of 25 years is the appropriate sentence. There will be a $5,000 fine along with a $5,000 compensatory fine. The no contact order will remain in effect through the court's jurisdiction, the term of the sentence. And restitution will include that amount that has been stated unless there's an objection to the $1,200. And in addition, it will be held open for the reasonable counseling services that are expected because of a case such as this. Mr. Morgan, this is the court's sentence. You have the right to appeal this judgment within 42 days. Post-conviction relief expires a year after that, and a Rule 35 expires in 120 days. And Mr. Anderson will spend time with you to describe whether any of these remedies have any applicability. So thank you, and you may be excused.